Ma'am, court officer, ma'am. Madam ಅವರೇ, list number 2, serial number 6.
ಪಾಸ್ ಓವರ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
Okay, ma'am. Okay, thank you.
ಯಾವ್ದು ಸರ್? ಯಾವ್ದು? ಮೋನೇಶ್ ಕುಮಾರ್ ಅವರು ರವಿ ಬಿ ನಾಯಕ್ ಸರ್ ಆಫೀಸು. ಎಲ್ಲಿ ಇದು? ಕೆ.ಬಿ. ಮೋನೇಶ್ ಕುಮಾರ್. ಲಿಸ್ಟ್ ನಂಬರ್ 2, ಸೀರಿಯಲ್ ನಂಬರ್ 2. ಒಂದು ನಿಮಿಷ. AGF R1 to R5 ಇದೆ. R3 ಏನು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇನೆಂಟ್ ಏನೋ ನೋಡಿ. R13 MD ಹನುಮಂತ ಇವ್ರನ್ನ ಕೇಳಿ, ಮಂಜುನಾಥ್ ಅವ್ರನ್ನ. ಸರ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅದರೊಳಗಡೆ ಮೋನೇಶ್ ಕುಮಾರ್ ಸರ್ R3 ಅಂತ ಅವರ ಸ್ಟೇಷನ್ ಹೌಸ್ ಆಫೀಸರ್ ಆನ್ ಬಿಹಾಫ್. ಅದೇನೋ ಫೋನಲ್ಲಿ ಮಾತಾಡ್ತಾವ್ರಿ, ಹೇಳ್ತಾರೆ, ಅವರೇ ಹೇಳ್ಬೇಕದು. Madam, we will call all matters remaining are pass over matters only. Registry to verify the wakalat filed by R3 ಅಂತ ಇದೆ. ಎಲ್ಲಿದೆ ವಕಾಲತ್ತು? ಇದೆಯಾ ಅಲ್ಲಿ ನೋಡಿ, ಕರೀರಿ ಅವ್ರನ್ನೇ, ಬ್ರಾಂಚ್ ಅವ್ರನ್ನ. ಅದೇ ಮೋಸ್ಟ್ಲಿ VK filed by advocate for R3 ಅಂತ ಬರೀತಾರೆ. Register verify the VK filed by CO CH9 CH9 ಅಲ್ಲಿ ಇದ್ದಾಗ ಇದು ಆರ್ಡರ್ ಆಗಿರೋದು. ಅದು ಕರೀರಿ ಅವ್ರನ್ನ, ವಕಾಲತ್ ತಗೊಬನ್ನಿ ಅಂತ ಹೇಳ್ತೀನಿ. ಯಾವ್ದಿದು ಬ್ರಾಂಚ್? DM ಪೊಲೀಸ್ ಅಲ್ಲ? ಹಲೋ, ನಿಮ್ಮ ಹೆಸರು ಇಲ್ಲಪ್ಪ? ಶಿವಮೊಗ್ಗವರು 4740ನಾ? ನಿಮ್ದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಕೆ.ಬಿ. ಮೋನೇಶ್ ಕುಮಾರ್ ಅವರು ಸ್ಟೇಷನ್ ಹೌಸ್ ಆಫೀಸರ್ ಆನ್ ಬಿಹಾಫ್ ವಕಾಲತ್ ಆಗಿದ್ದಾರಾ? ನೀವು 1 to 5 ಅಂತೀರಾ. AGA 1 to 5 ಅಂತಿದೆ. ಆಮೇಲೆ 2ಗೆ ನೋಡಿ, 3ಗೆ ಅಲ್ಲ ಶಿವಮೊಗ್ಗಪುರ ರೀ. ನಿಮ್ಮ ಸ್ಟಾಫ್ನೆಲ್ಲ ಒಂದು ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿ ಟ್ರೈನಿಂಗ್ ಇರ್ತದೆ ಏನ್ರಿ? ರಿಪೋರ್ಟ್ ಆರ್ಡ್ರು ರಿಜಿಸ್ಟ್ರಿ ಟು ವೆರಿಫೈ ದಿ ವಕಾಲತ್ ಫೈಲ್ ಬೈ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಅಂತ ಪ್ರೀವಿಯಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಲ್ವಾ? ಎಲ್ಲಿದೆ? ವಕಾಲತ್ತೆ ಪುಟಪ್ ಮಾಡಿಲ್ವಲ್ಲ ನೀವು? ಅದು ನಮ್ಮ ಫೈಲ್ ಜೊತೆಗೆ ವೆರಿಫೈ ಮಾಡಿದ್ರೆ ವಕಾಲತ್ನ ಹೋಗಿ ಬನ್ನಿ, ಇವರಿಗೆ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ, ವಕಾಲತ್ ತಗೊಂಡು ಬರಕ್ಕೆ ಹೇಳಿ ನಿಮ್ಮ ಕೇಸ್ ವರ್ಕರ್ಗೆ. WP ನಂಬರ್ 25343 ಆಫ್ 22 25343 ಆಫ್ 22 ನಲ್ಲಿ R3ಗೆ ಪ್ರೈವೇಟ್ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. 22 ನಲ್ಲಿ 2022 ಅದರೊಳಗಡೆ R3ಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಸ್ಟೇಷನ್ ಹೌಸ್ ಆಫೀಸರ್ ಪರವಾಗಿ. ಅಲ್ಲಿ ವಕಾಲತ್ ವೆರಿಫೈ ಮಾಡಿ ಅಂತ ಕೋರ್ಟ್ ಆದೇಶ ಆಗಿದೆ. ಹಿಂದೆ ನೀವು ಅಪಿಯರೆನ್ಸ್ ಮಾತ್ರ ತೋರಿಸ್ತೀರಾ, ವಕಾಲತ್ ಎಲ್ಲಿ? ಅಯ್ಯೋ ಅದು ಬದಲ ಅಲ್ಲರಿ ಕರೆಕ್ಟ್ ಇವಾಗ ನಾವು ಕೆ.ಬಿ. ಮೋನೇಶ್ ಕುಮಾರ್ ಅವ್ರನ್ನ ತೋರ್ಸ್ಬೇಕಾ ಬೇಗ ಅವ್ರಿಗೆ ಆಕ್ಲಿಗೆ ನೀವು ತೋರ್ಸಿದೀರಪ್ಪ ಆತ್ರಿ ಆರ್ಟ್ರಿಗೆ ಅಲ್ಲಿ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಕೆ.ಬಿ. ಮೋನೇಶ್ ಕುಮಾರ್ ಫೈಲ್ ವಕಾಲತ್ತು ನೀವು ತೋರಿಸ್ತೀರಲ್ಲ AG accept notice for R1 to R5 ಅಂದ್ರೆ ಕೆ.ಬಿ. ಮೋನೇಶ್ ಕುಮಾರ್ party's name ನಿಮಿಷ ಇರಪ್ಪ ವನಶಂಕರಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಮೀನು ಅಲ್ಲ ವನಶಂಕರಿ ಮೀನುಗಾರರ ಸಂಘ ಇಲ್ಲಿ ಬರ್ತಿದ್ದೀರ ವ್ಯಾಪಾರನೆಲ್ಲ ಕೆ.ಬಿ. ಮೋನೇಶ್ ಕುಮಾರ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ವಕಾಲತ್ ಫೈಲ್ ಅಂತ ಬನ್ನಿ ನೀವು ಕೇಸ್ ಪೇಪರ್ನ ಕಳಿಸಿ ಕೋರ್ಟನ್ಗೆ ಅಲ್ಲದೆ ನೀವು ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿಂದ ಪಕ್ಕಕ್ಕೆ ಶಿಫ್ಟ್ ಮಾಡ್ಕೊಂಡಿರೋದಕ್ಕೆ ಇಷ್ಟೊಂದು ಫೈಲ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತಿರೋದು ಏನಾದ್ರು ಡ್ರಗ್ ಹೌಸ್ ಕಳಿಸಿದ್ರೆ ಡ್ರಗ್ ಹೌಸ್ಗೋ ಅಥವಾ CTC ರಿಪೋರ್ಟ್ ಕ್ಯಾಂಪಸ್ಗೋ ಕಳಿಸಿದ್ರೆ ಫೈಲ್ ಬೇಗ ನೀವು ಒಂದು ಕಳಿಸಿ ಕೇಸ್ ಪೇಪರ್ನ ಇದೇಪ್ಪ ಕಳಿಸಿ ಇವಾಗ ಅವ್ರನ್ನ ವಕಾಲತ್ ಇದ್ದ ತಗೊಂಡು ಇಲ್ಲಾಂದ್ರೆ ಮೋನೇಶ್ ಕುಮಾರ್ ಅವ್ರನ್ನ ಕಳಿಸಿ ಇನ್ನೊಂದು ವಕಾಲತ್ ತಗೊಳ್ಳಿ ನೋಡಿ pass over matters.
My lord,
Number one.
withdrawn, my lord, second list, serial number 7.
Take that.
Each policy.
What is that?
7.
7.
Yes.
Any instructions? No, you were saying something. No, the memo is filed. Seeing to withdraw the petition, memo is taken on record and dismissed as withdrawn. Yes, for the rest.
4 matters, list number 1, serial number 17, Sangeeta Sangan, for petitioner, Vignesh Jetty.
What are your instructions? Huh? Oh, is this the case that you were saying IA is against IA this order is filed? Let's see what is the prayer sought. Let's look at the prayer. Set aside the order dated 31/2026 passed by the Deputy Tribunal. Where is the order? Morning, what happened? They asked for a passover. No representation. Morning, the matter, the council requested for a passover. In the afternoon, when the matter is called, no representation. List for dismissal tomorrow. Next.
Serial number 25. Serial number 25.
Yes.
22.
20?
22, that part.
22. I'll take up 22 and then. Where is the counsel for the respondent?
Serial number 22.
Yes. Whatever that concise version is saying, no, that is. So where is your prayer?
Yeah, it's in page 1391, my lord.
1391.
Yes, ma'am.
Call for the record and set aside the illegal order of cancellation, confirming the respondent BDA, cancelling the allotment deed of the scheduled property, to call for the records and set aside the judgments and decrees as being null. There can't be a prayer like this.
Yes, my lord.
There can't be a prayer like this.
Oh, okay.
Why to set aside orders dated 6/11/2018 and all that you can't question in one writ petition like this? The judgment dated passed in writ appeal number. The judgment dated so and so. No, if you want an order dated 6/11/2008 to be set aside, in that petition you need to file up an application to recall the order. You can't seek it by way of a separate writ petition, as like in a civil suit seeking that that decree is not binding on me.
No, not like that, my lord. Actually, what has happened is there is a civil suit pending on this.
No, whatever.
Yeah.
Please come to your prayer, B.
Yeah, prayer B.
B.
Yeah, issue a writ of certiorari.
Set aside the following judgments.
Yeah.
It cannot be set aside like this. So this prayer itself is not maintainable. We can't set aside an order that is passed in some other writ petition basing on your writ petition.
Yes.
If you are agreed by any order passed in that, if it is legally permissible for you to reopen it and ask for a review of it, you can do it
No, because
independently.
the thing is, what has happened is there was a RFA pending in the same court.
I understand. Whatever it is, we can't do it. So, if there is any other mode available to you to question this, you please do it. Then coming
There
to
is no other mode, my lord, because
we can't do it.
they have entered my property while the RFA was pending.
No, that independently we can see. But an order that is passed by the earlier courts, which has attained finality, cannot be set aside in a further subsequent writ petition. There can't be such a relief.
Yeah, it's because basically there is the correct.
You want to engage an advocate from the Legal Services Authority?
I already tried, my lord. They didn't give me an advocate.
They have not. Why not? Why will not they give?
I don't know.
Because then
there is merits in the case.
no, then you will understand. He will explain to you what is the legality of these kind of prayers, which you can't. So there are certain we work under some. There are some legal parameters for granting or not granting, entertaining a writ petition.
Uh-huh.
I'll direct the Legal Services Authority to assign an advocate to you.
Uh-huh.
Then
Yeah,
let
but can I change this and amend this?
not change that? Ultimately, when did you file this writ petition? It's in 2022.
True, my lord.
Even for the next 10 years, it will be pending like this.
Yeah.
You need to have a proper legal advice.
Uh-huh.
The,
No, my lord, the problem is we are out of the house. We are homeless.
but 22, from
They are-
2022 it's happening.
They are sitting in my property with paying electricity bills in my name, and EC everything is coming in my name.
What exactly is this case?
But he is saying that the Bangalore Development Authority, officials of the BDA have illegally evicted him from the place. And Lord, he has filed a suit now, and he ought not to have been evicted. This is
But
his case.
eviction means what is the, how you are, he is evicted?
Lord, his mother, Lord, had two sites. There is a bar for having a second site. But what had happened is in the second site, which he claimed, she filed an application, she did not disclose it. They have agitated before this honorable court. This honorable court, up to Supreme Court, they have agitated. He
It is held
says
against them.
it has gone against them.
Hmm.
He says this property has fallen to his share by virtue of some document, which he claims that it has fallen to his share. They could not have agitated the matter. This is his case. He is making
No, ultimately the allottee is the mother.
allotment.
Allotment is held to be wrong.
My lord, can I speak?
I'll hear you. Yes,
But held to be wrong, that is challenged and that is attained.
retained finality.
Then we have evicted.
Evicted him. Hmm.
So that is what he has been now contesting.
When was he evicted?
Not long back, in 2021.
21.
Then what did he do when he was evicted?
That he has been filing papers and papers, but is not
No, my lord,
concluding
my lord,
yet.
my-
If once he concludes saying that I'll not file any more documents, my lord, I'll concisely reply to all. From 2019, my lord, 22, this has been going on. Every 15 days, I get a paper.
My lord,
In the last occasion
If you're
also,
right,
Lordship suggested him to have an advocate. But I'm now told in RFA he had an advocate. There's some dispute with regard to that. I don't want to get involved into all those things. No, I don't want to make submissions on that also. But probably, as your Lordship suggested, Lord, he may seek legal services.
No.
my lord, I would like to make a small submission.
Sir.
My lord, he's wrong. My mother was not allotted two sites. My father was allotted a site by the CITB, but they say by the BDA. It is wrong, right? And secondly, my
What is
mother's
TBA?
CITB, City Improvement Trust Board, in 1975,
Predecessor in
right?
of
Now,
BD.
coming back to this, my mother's allotment, my mother was allotted a site in 2008, right? And they have issued a cancellation order, in 1988, she was allotted a site, my lord. And they have issued a cancellation letter dated 2008. So it is all 20 years, 6 days short of 20 years. Now, there is a law here, basically, in BDA Act, that any action beyond 18 years is not sustainable. Now, BDA is a public authority. They cannot say that we don't know that law at all.
Let's see. Give that.
Yeah, I've given it, my lord. I've
You
given
read
it.
this, you read the section. I'm asking the court officer to give the act.
Yeah.
No, the difficulty that comes in this is, even if this court, Mr.
Ashfaq. My lord, yeah, rules.
No, please listen to the court. Now, assuming that this court accepts your argument and BDA has no power to cancel the allotment in favor of your mother,
Yeah.
then still the other three judgments which have already attained finality will
Yeah.
be staring at you.
Yeah.
So you will be successful if you approach the authority who has passed or the court which has passed the order and seek a review of the order.
No,
An
my lord.
order that is passed in a writ appeal cannot be set aside by a learned single judge. You understand?
No,
that?
but the Supreme Court says that any order taken by suppression of material facts and misconstrued,
Supreme Court also says
yeah,
an order passed by a division bench, a single judge will not, whatever, if it is suppression also, single judge will not set aside that. That's why you have to understand the legal complications, implications, take a proper advice, then you should proceed. if you want to get any relief from the courts. Now file a writ petition in 2022, we are in 2026.
I've been running after for 3.5 years.
Correct, but you can't get a relief
My lord,
as it is.
the problem is they're totally a renegade authority. They don't reply to RTI applications. It has taken me 3.5 years to get a RTA.
What is that you want from them?
I just want them to vacate my house and
No, not that.
Yeah.
What is that you want them under the Right to Information Act?
I've made a lot of applications. That's what.
What is that? What do
That
you
is
want?
what the internal documents, right? The internal documents.
We'll do one thing.
Yeah,
You come up with what is that? What is the information you want from them?
yeah. No, I've already got it from the KIC.
Then it is done
I
now.
already made submissions also to the court.
So,
Yeah.
the reliefs as you are seeking in this writ petition cannot be granted legally.
Yes, my lord. So what is
What is the recourse available to you is, now, writ appeal also, nothing can be done because writ appeal order is carried to the Honorable Apex Court. Apex Court has affirmed the order
Yeah.
saying that allotment in your name of your father or mother is not right.
Yeah.
So when that order
No.
has the same finality, we can't dig it again.
No, my lord, the Supreme Court says that there is an, citation I got. The Supreme Court says that any SLP dismissed in limine, that is without any orders, can be challenged back in the High Court. It can be gone back to the High Court. No, I can't
Now
go.
you come to, then what you're supposed to do, go to the division bench.
Yeah.
In that writ appeal, you file a review. Saying
No,
that-
review is, I can file a review, but they have entered the property illegally. They have violated my fundamental rights. My fundamental rights under Article 300A, Article 21, all have been violated. my
According
lord.
to you, it is violation of fundamental right. According to them, in the light of the orders passed by the courts, they are entitled for that and they have done it. So now the remedy available to you is to seek review of the order or do whatever, but this writ petition cannot be maintained. And it is just you're wasting your time before this court. Even after 10 years also, you will not get any relief. So, or else I can do one thing. I'll adjourn this matter.
Yeah.
Take a proper legal advice.
Yeah. Can I make some corrections as you said?
It's not corrections. Whatever you correct it, it will not serve the purpose.
Yeah.
Because as far as allotment is concerned, that has attained finality. Somebody has to review that order independently. No, this is not open for this court to review the earlier orders.
Yes. My lord, orders taken by fraud are, they can be reviewed, my lord.
That's
I've
not
got
the law.
citations.
You know the judge, you know only the head note of the judgment. How it applies, we know.
Yeah.
It can't be applied.
And secondly, what has happened is they have misconstrued my mother's affidavit. My mother's affidavit clearly says that she does not own a site or a house. But the orders of a writ appeal and the writ petition,
No, why can't, when was the order in the writ appeal?
it was in 2009, my lord.
2009, 14 July 2009.
2009.
Then from 2009 to
That's what, 2009, they kept quiet.
21, you were waiting.
No, they were, it was carried in SLP. Not
Oh, that was pending from 9 to 21.
No. The SLP was dismissed in 2009 only. No, then the proceedings, that's why I'm saying if completes anything, but I'll secure instruction, but there will be various sections from where I'll have to secure instruction, put it into it. Then there.
Even a writ appeal of
No, then
2000.
7 years, they have not done it. madam.
Yeah.
7
was
years.
filed.
Please wait. How can a writ appeal of even,
But there will be public premises eviction.
what is the
Act.
suit for?
Suit for blood is bare injunction only.
Injunction restraining you from interfering.
Yes.
But that has become now infructuous. No, you have already, he's not in possession of the property.
My lord,
No,
they are telling that it has become public premises.
public
I will
premises.
prove that the Public Premises Act cannot be applied to BDA allotted sites.
Public premises act.
The remedy for,
No, probably what I can understand from his argument is, there are some grounds to say that the property is not allotted, 2 plots are not allotted, something is there with him.
No, my lord.
Allotted.
From what his argument is.
Yes.
Now, even if he is able to prove that before this court cannot do anything.
But
my lord,
he
they
is-
cannot apply public
When
premises.
he's asking what is the remedy available to him, you can't advise him what is the remedy because there is no remedy now. Everything, all the doors are closed.
They cannot apply Public Premises Act on this property, right? The remedy is section 31 of the Specific Relief Act. That they have not.
Will direct the Legal Services Authority to engage, to allot a counsel to you who will, so that with the counsel, you can, all your judgments and everything, you can have a consultation with him. Then you will understand where exactly you stand. Then you can come up before the court again.
Yeah. 3.5 years I've been running around, my lord.
But now,
At least don't dismiss it, my lord.
it just takes a minute to dismiss your case.
Please
But
don't.
I don't want to do it, that's why I'm.
Now we are homeless. My
It can't
kids
be
are.
doing it. If whatever. If
No,
you
no,
are
they
not
have, what they have done is, well, no, no, what
The-
I'm, during the pendency of, they have violated doctrine of
the
lease pendency.
party in person appear before the
May I
court
say
and find.
this? I appear for respondent number 1. Insofar as prayers E, F and G, my lords,
We are not going into that.
please.
The petitioner party in person has filed a writ petition in the year 2022, questioning the action of the respondent and also seeking several reliefs. It is this case that the property is in the family partition fell to his share, and the BDA has cancelled the allotment in favor of the mother, saying that the no party is entitled for 2 allotments, and the said fact is not disclosed. And they have
No, my lord, we have, it's not, no question of disclosing, my lord. My mother has not been allotted 2 sites. They are misrepresenting.
I'm not passing any order. Please listen to the court. I'm not passing any order.
Okay, okay.
What did you write? They have forcefully evicted him from the premises. In
The
this regard,
eviction was very violent, my lord. And
in this
they have
regard,
taken away all my
they have
belongings.
filed a suit, and now he has filed this writ petition.
My lord,
This court has seen the prayers. This court has perused the prayers that are sought before the court. This court is of the view that the parties in person requires a strict legal opinion and also legal assistance of a counsel. Hence, the Legal Services Authority shall entrust this matter to a counsel who is having considerable standing. Yes,
my lord.
the petitioner shall approach the Legal Services Authority. They will engage an advocate for you.
Yeah, my lord, I want to just tell you one more thing. Which BDA Act they can take away our personal belongings and hold it to ransom in, I got the proof of, they have told, which BDA Act or they say Supreme Court has ordered seizing of all our personal belongings. So will the Supreme Court order, my lord?
That you ask your counsel, he will tell. I can't tell you that. Yes, next.
Till number 25.
Any next date of hearing, my lord?
Unless this matter on 23rd of April. Yes.
Till number 25. Yes,
Yes, I appear for petitioner. my lord.
Petitioner.
Morning, respondents took part.
Thank you, my lord.
This is a case where my lords, petitioners before my lords are my lords, neither the borrowers nor the guarantors. Respondent number 2 is the my lords borrower who availed loan from the bank. My lords, respondent number 1, bank has project loan. Now, my lords, on the last date of hearing, I made the submission that my lords, there are other 2 apartments owned by my lords, the second
Yes.
respondent.
You said that's a commercial thing can be sold.
Yes, please, my lords. Now, I have one more instructions, my lords, to submit, my lords. This commercial space, my lords, 2,600 square feet, what, my lords, my learned friend on the other day submitted that, my lords, it is half constructed and not, my lords, completely constructed. My instructions are, my lords, if they are ready to give, my lords, association is ready to buy it, my lords, for, my lords, whatever, 1.5 to 2 crores, that is what they are saying. For that price, my lords,
Then that incomplete.
uncompleted, my lords, as it is, we are ready to buy. And apart from that, my lords, other 2 apartments are there, my lords. The association is, my lords, ready to buy those 2 apartments, 1 single bedroom and 1 2-bedroom apartments are there. If they are ready, my lords, they are ready to, my lords, purchase these 2 or 3 properties.
My lord, these are all, my lord, these are all
And
now
I'm sorry, my lords,
only
there is one.
talking point, my lord.
Huh?
These are all only talking points, but this entire exercise has been done for all so many years. Nothing has happened now. Your lordship said, now do find out this commercial property. I have brought and it is a memo also.
The
There it is
unfinished one.
not constructed and all, my lord.
Oh, they say they will buy it unfinished
No,
one.
but how they will buy?
That's their problem.
My lord, that sale, that is what my lord, if the sale now is whether they will participate in the bidding. Because already that honorable court that just to defer that sale notice. It is not cancelled or not stayed. This honorable court. Now, whether they will participate and buy the entire thing because it is only 7 crores. Now, there are so many apartments are there. Now,
Yes.
the issue is, my lord, now, issue is,
What is the amount? due to
amount
the
is seven,
bank?
it comes up to 7.5 crores.
Hmm.
Entire
No.
amount. Now, these petitioners, they are not the owners of the property and nothing, they have no status at all. As per 17 of the Surface Act, a good person, either borrower, guarantor and all, and tenants and leasehold right owners. And they will not come under any category. Now, the bank, they have been trying all the exercises and all, including everything, and now they have occupied illegally, some about 13% they have occupied the premises. Now, these people have come to the court. Now, there are so many flats, about 30, 35 flats. 13% they have come to the honorable court stating that don't take action. Now, my lord, that their prayer, your lordship kindly see prayer. Now, the bank has issued a sale notice to sell the property because all the properties are standing in the name of the borrower. And flats constructed and all entire thing is they have mortgaged the property.
No,
Now,
the other day you were saying that the sale deed is not executed in their favor till now?
no, unregistered sale agreement. Nothing is sale deed executed means there is no issue at all because automatically they have got right. They will become a
No,
good
sale
person.
deed in your-
My lords,
There is nothing is there.
my lords, on the last date of hearing itself, my lords, I made the submission, my lords, some have approached RERA authority, some have approached
Who
consumer
has
court.
approached this court?
My lords, these petitioners, my lords, are the purchasers, my lords,
No,
agreement
no.
holders,
One minute.
agreement holders, my lords.
Yoga, what is it? Voyager
Voyager.
Voyager, that is
Apartment Owners Association.
association.
Unregistered.
Where are the apartments?
My lords, now,
Apartments
now
not
that is
registered
what,
also.
my lords, now, my
No,
instructions.
no.
Yes, please.
Apartments constructed, completed.
Yes.
Then they will come when it will form into an association.
And they have to register also under that.
Now,
act.
this is, my lords, the registered, my lords.
So can this association represent all of you?
Lords, yes, my lords.
Well,
Now, the other owners are also party, my lords.
You're given the apartment numbers also when in a.
Yes, my lords, that is what I am submitting, my lords. What the respondent number 2 has done is, my lords, he has availed project loan after completing the, my lords, project.
But it's very difficult for this court to determine.
Now, my
all
lords,
this.
the contention that, my lords, they have brought the entire property for auction, that cannot be
I'll
considered.
I'll give you 4 weeks time, go before the DRT.
Yes, my lord.
Lords, I may submit one more, my lords, issue here, my lords. Lords, so there are about, my lords, 9 apartment.
But please understand.
Yes,
If the court is passing some order in favor of a person, in whose favor the rights, you have no ownership to the property in the eye of law.
Yes.
So how come this court is considering all that? Just only on that point.
lords.
If you have a valid sale date, something else has happened, I can understand.
Yes,
Assuming and presuming things, we can't pass an order.
lords, may I submit this? Consumer courts have passed the orders. Now, only to defeat those, my lords, orders or
No,
awards.
wherever the consumer forum, without considering any document, anything for whatever, because the parameters for a consumer court is altogether different. When you're coming before the
Yes,
court, first of all, you should assert your title to the property or right to the property. That is not, because there is no document in the eye of law to say that you are the owner of the property. In those circumstances, how can we consider your case and say you purchase this property, sell this property?
No, my lords, my respectful submission is, my lords, the contention of the bank, that, my lords, they have brought the entire property for auction also cannot be considered because, lords, sir, they have sanctioned 9 loans to the individual apartment owners. Individual apartment owners have purchased this, my lords.
But to a writ petition filed in this manner, there are several people and each person is asserting their right and title to the property by way of different thing. And one order to the bank saying that don't conduct the auction.
No, my lords, now
All of you are, if you can prove before the court that you're interested in this matter, the DRT will consider all your cases. If you want instruction,
My
I
lords,
can extend the matter.
may my lords request for time till Monday or Tuesday, my lords, I'll come back.
Matter on.
25th, my lords.
No, not necessarily. We'll have it on 6th of April.
Please,
Get
interim
your
order to
instruction.
continue.
Interim order is, that day we
Please,
will pass
in the
on.
meantime, I'll also.
Because they were all having
Because my
the,
lord.
Yes,
And that I told my lord, if this sale is permitted. If the
I understand, I
vacated means,
Let's
nobody
buy.
will come to participate, then that settlement will take place. But now
not for
simply
you, I
dragging
can
on the matter, my
understand,
lord.
you're a borrower, you're a
Yes.
builder, you are something, we can
Nothing
pass
is
such
there.
order.
yes, please. Now it is.
You're asserting title
Now,
on
respondent number 2, my lords, being a borrower, he says, my lords, when this property was brought for auction in the year 2022, he requested us to,
You represent for
he is
respondent
the
number
fees
2.
for the borrower.
Okay, for respondent.
One is on 2nd of April. we'll
6th,
pass.
6th.
Yes, 2nd of
End of
April.
April.
Yes,
We
ma'am,
finally
2nd of
passed.
April.
Let him get instructions. And anyhow, we will relegate them to the, if they have a remedy before the DRT, they'll go.
Yes, ma'am.
My lord said 6th of April.
Hmm?
2nd
6th of April.
Second.
Interim
Yes,
order
yes.
to continue.
Interim order earlier granted is extended. Yes, next.
33. 33, Neeraj Rajiv Shivaram.
Hearing for the
My lord, today
petitioner.
I received copy, my lord. Kindly have it tomorrow, my lord. We'll see
Tomorrow.
against.
My lords, one submission, my lords. I placed the OTS before the bank, my lords. Until then, let them not precipitate on any.
But tomorrow, nothing is going to happen. I will dispose it of tomorrow.
Please.
Yes. Tomorrow at the request of Mr. Vignesh Shetty, bring the name of Mr. Vignesh Shetty in the cause list.
Then number 39. 39,
Sir, I'm appealing for the respondent bank, my lord.
Mahesh.
I appear for respondent number
Chaudhary.
3 in this case.
Sandeep.
Come to your prayer in the first writ petition,
Your lordship,
1835 of
is
20.
Passover possible, your lordship? Senior is on his legs in Court Hall 11, your lordship.
How many times we can pass over? Morning it's passed over,
I
again
understand.
for another Passover. Yes, ask him to come next, we'll call this matter around 3:30.
Please wait for the.
Yes.
Then number 40.
Up.
40.
Here for the petition. I'm sorry, my lords,
Yes.
not there in the morning. But the issue is not with regard to the applicability of amended rules to, my lord, an agreement which is already entered into prior thereto.
Don't give the, only give the petition. Please the petition. If everything they tag on how to deal with that. You can make 2 volumes of it. Cut that. Where is your prayer?
My prayer is at page 42. First,
Notice issued by the 4th respondent.
please.
Who is the 4th respondent?
Fourth respondent, my lord, is the port officer.
Hmm?
Port officer.
Port office.
Port.
What is the notice issued?
But what has happened is, Lord, I'll just give in a nutshell, Lord, I'll not take notes. After that, I'll take the quote the entire documents. But I was supposed to establish a thermal power plant. Lord, and Lord, certain allotments were made in my favor by the KIDB. KIDB is
And
Karnataka
was
Industry.
allotted to you.
Yes, Lord. And the government state of Karnataka entered into an MOU with me saying that I will give you this extent of land. You establish a thermal power plant. Now, my Lord, the KIDB and the government were unable to give me this land.
When was the allotment?
Please, Lord.
Allotment was when?
But allotment was done to me, my Lord, sometime in 2010.
Yes.
But then, Lord, for the purpose of this thermal power plant, Lord, I needed a captive jetty. In the port, Lord, they'll have a captive jetty where only, Lord, my goods will come. For the thermal power plant, I had to get this, Lord, power jetty. So, Lord, I also approached, Lord, the respondents for a captive jetty, keeping in mind that I need it for the thermal power plant. In the interregnum, what happens is, although the agreement and MOU accepted in 2010, nothing happens. Out of 1,100 acres, it is supposed to given to me by the government for
1,000?
1,100 acres, Lord.
Hmm.
That was to be given to me, Lord, for the thermal power plant.
Hmm.
KDB issues final notification for 11 acres.
When?
But that, Lord, final notification, Lord, was issued in 2012.
Hmm. Hmm.
So then, Lord, I realized that the KDB is not in a position to give me the land at all. So then I write to KIDB saying that please give me back my money because I deposited about 17 crores with the KIDB. I said, you give me back your money. You're not in a position to give me the property. There's no point in giving the money to you.
What is the money you paid?
But I paid about 17 odd crores to the KADB.
When?
Not that not was paid not sometime in 2012 or so. Not I'll give those dates. So there not therefore I approached this honorable court seeking for refund of the KDB gave me a portion of the amount and then forfeited a portion. I approached this honorable court saying the forfeiture is illegal because you cannot forfeit because it's your fault you did not give me the property. This honorable court not held in my favor and directed refund of the entire amount along with the interest. Writ appeal also is confirmed. Now not the government has gone and
No, the entire amount is refunded to you.
yes, no, not yet refunded, not because there is an order, writ appeal is confirmed. The KIDP has now gone to the Honorable Supreme Court. Only insofar as the interest notice has been issued. Now, parallelly insofar as these proceedings are concerned, where I sought for a port, this captive jetty, I in the interregnum also asked these people, please allow me because nothing is happening.
Oh, when your allotment itself is cancelled, now why do you require this cap?
I don't need it. In fact, my prayer with regard to the cancellation, I'm not going to press. Now, the only issue that remains is what has been done is this agreement or lease deed was executed in 2012. Whereas the amendment was brought into the rules in 2014.
Amendment to which rules?
Rules, that is the, give me a second. It is called the Karnataka Ports Landing and Shipping Fees Amendment Rules 2014. Now, this amendment came in 2014.
No. Before going into that amendment, the whole purpose why you approach the port authorities is for the purpose of your
yes.
the land
yes.
allotted to you
yes.
for the
yes.
thermal
yes.
power, whatever the project you are in. No, that itself has gone.
It has gone.
No,
now they have terminated this lease. They have terminated. But I'm not going to challenge the termination. It is there, but I'm not going to press it. My only grievance will remain with regard to the fee that they levy. Under the agreement, it was.
Oh, by virtue of this notice, what is the implication of it?
Implication is I'm called upon to pay, but as per the lease deed, the amount was 15 rupees per 10 square meters. That was the fee that was fixed. But the amount that is now levied on me is 75 rupees per square meters, which is as per the amendment.
When was the your allotment at 15 rupees?
That was at the year 2012. That is not the order is dated 22/2/2012. The agreement is dated 29/8/2012.
29/8/2012.
8/2012.
So as on 2012.
Please.
It was 15 rupees per
10 square meters. Then government issues an amendment on 22/11/2014. Wherein the amount is increased from fivefold. From 15 rupees, it is increased to
75. Now, by virtue of this notice, from when to when they are claiming the 75 rupees?
But this amount they're claiming from 2014 onwards.
Then all rule now, when the new rules have come into force,
Please.
that would apply to everyone.
No, Lord, it will not apply with my submission. One, Lord.
So, for example, now we are in 2026. You are still continuing. According to you, what was the rate as on 2012 should be continued forever?
No, Lord, what happens is two things. One, as per this rule, it is applicable to commercial or industrial purpose. I'll take lots of that as well. Whereas mine was a captive jetty. So I don't fall in either of those two categories at all. Therefore, the amendment will not apply to me is one. Two, Lord, once there is an agreement which is executed between the parties, which says this is the amount that is payable, but can the government thereafter amend?
Let's see those documents.
Please.
Where is the agreement between you and the government?
Please, Lord. But the agreement between us is at page 235. But the lease order, Lord, is in Kannada. I don't know.
Who appears to the government?
I pay for the state in this matter. Lords, the lease agreement specifically incorporated any further statutory changes. What was, Lords, the rates that were fixed, Lords, are statutory in nature. Whatever the statute provided as on that day was incorporated, Lords, in the lease deed.
It says so.
It says so, and it also says that as revised from time to time, as statutorily revised from time to time. So it has been settled, Lords, by judgments of the Supreme Court that if it gets revised, it is in the nature of a statutory contract itself, where if any revision takes place, it has also been statutorily incorporated, contractually incorporated in respect of further. What he is saying is, now he is ready, he has paid, he is liable to pay, my lords, the increased charges. My lords, he might have a big vision, my lords, that I need to set up one thermal power plant in one place, another some other project in another place, and therefore I'm taking. But here he has taken that it was in his possession, the entire land was in his possession, so therefore the ground rent is liable to be paid. All that, my lords, we are saying is just pay the ground rent. Now, my lords, cancellation, my lords, he has accepted it. That only when during the time when the land was in your possession, that the entire extent was in your possession, the ground rent. Otherwise, my lords, it's a loss for the state. Now he is it is incorporated. Unfortunately, that document, my lords, is in Kannada. It has not been in translation. But
Where is that page number?
Lord, page 228, my lord, is the order.
Is that fine?
May I conclude, because may I continue, my lord, instead of my learned friend?
No, I'll just quote as
Very well.
I knew it was in Kannada. That's good.
Translation.
No, whichever is the easiest way of, now you said something, immediately if it is clarified and we can
Very
go
well.
further instead of wasting time.
Yes.
220?
Lord, that's at page 228. But two difficulties that arise in this is, Lord, the order imprint also is in Kannada.
How big is the order?
Lord, it's about.
No, anyhow, both of you are here to,
Yes,
somebody
yes.
is not. if
I have
somebody
no
is saying-
difficulty, Lord. Therefore, if lords are
We
not
can.
comfortable with that, Lord, I will.
Yes, yes. So now where is that? This is a lease deed at 227.
But can I request the court to please turn to page 228? It starts. The first part itself refers to the.
This appears to be an order.
Please.
This is an order.
So this is the lease order.
Ah.
This is the lease not executed in my favor.
Hmm.
But the starting
He is
refers
referring
to
to
the.
something with regard to the changes or any amendments or.
I'll take my lords to that as well.
Oh.
Lord, then not this. I'll just show the amount that is fixed here. The lease order, Lord, is dated 22/2/2012. But the amount is in English. Lord, please see the purpose. It is captive jetty. Lord, I'll take my lords to definition of captive jetty. Then lords, to be established so and so square meters, etc. Then lords, at the rate of prati tingalige, that is 15 rupees for 10 lords square meters.
Yes.
Bhu badige vidisi, that is fixing the ground rent, and yearly 10% increment. But there the order says it is going to be 15 rupees with increment at 10%. This is what the order says. Now, my lord, please then turn to there is a clause at page 232, clause 10. But there are two distinctions, my lord, I would like to make. One is with regard to rent, my lord, there can be no revision. What is provided in the agreement is revision on so far as penalty is concerned. Rent, my lord, is fixed. You can't change the rent. And then also, my lord, the fact would be, but I entered, kindly see the situation. 15 rupees is the rent given to me as per the lease. Government increases 5 times. It says from 15 rupees, I'll make it 75 rupees.
Let's see what is this other.
Please, this clause 10 says, not Sadari Samsteyavaru Bandaru Bhumi Badige is ground rent. Mattu Samkirige Sarakige Tagaluva Ella Bandaru Shulkagadannu Kala Kalake Barisatakkaddu. Timely payment has to be made. Hagu ಈ ಶುಲ್ಕಗಳು ಕಾಲಕಾಲಕ್ಕೆ ಸರ್ಕಾರದಿಂದ ಘೋಷಣೆಗೊಂಡಿದ್ದಲ್ಲಿ ಅಂತಹ ಶುಲ್ಕಗಳನ್ನು ಪರಿಷ್ಕರಣೆಗೊಂಡಲ್ಲಿ ಅಂತಹ ಶುಲ್ಕಗಳನ್ನು ತುಂಬಿಸಲು ಸಂಸ್ಥೆಯವರು ಬದ್ಧರಾಗಿರುತ್ತಾರೆ. What is to be revised is shulkagalu. Shulkagalu is not the other fees that is to be paid. Now please then turn to page 235, which is the lease deed.
No. Let's have the clarity on 10. What is according to you?
According to me, it
Clause
says.
number 10 says.
Yes, but it says.
That there would be enhancement or.
No. According to me, not the two different things are there. One is rent. Other one is other charges. Other charges should be revised, but not the rent, because the lease deed says rent is fixed at so and so with yearly increment. Otherwise, two become contrary to each other.
So please do one thing.
Please.
This clause number 10.
Please.
And the order impugned, both these two, you file a translated copy.
Very well.
The petition shall file the translated copy of the clause number 10 of the lease deed and also the impugned order.
Please,
When do you file? When can you file?
give me about 10 days time.
Let's this matter on 7th of April.
Great. Very good.
Yes.
Number 16. Pass over in disturbance, serial number 16. Rudra Bhushan CB. 60 is Rudra Bhushan CB for petitioner.
Yes. No representation. In the morning, the matter is passed over. In the afternoon, there is no representation. This is matter for dismissal tomorrow. Yes.
Number 2, pass over matters. Number 1.
In this case, I'm appearing for the petitioner, my lords. Lords, actually, I'm not keeping too well. I have undergone a surgery, my lords, after 2 weeks.
Which is serial number?
1, my lords.
Yes, tomorrow.
In this matter,
Lord,
lordship, this matter.
My lords, after 2 weeks, my lords, I had a
When she is not
surgery.
well, she wants to come tomorrow. Under
Not
the same
tomorrow,
time,
my lords, 2 weeks.
Huh?
2 weeks, my lords.
C report is
Huh?
matter. C report is filed, my lord.
C
in this
report
matter.
is
C
being
report is
filed.
filed.
No, my lords, they're rushing
69.
through the matter. They're rushing through the matter, my lords. And it is a thing that they don't want to take responsibility of the locker. I'll come after 2 weeks, my lords.
I
I'll come
just
in.
tried to repeat your log. I've served a copy. I've already sent a copy to her.
Yeah,
I can't
copy
serve a
only
copy.
came yesterday, my lords. Copy only came through mail yesterday, my lords. I received
This
only
is matter on
weeks. 2 weeks.
24th.
Much of
Yes, next.
My lords, I may make a submission, my lords. Serial number 60, my lords, I was held up in other court, my lords. Serial number 60.
60, list number 1. Rudra Bhushan.
My lords, this case was listed yesterday. My lords, this honorable court had directed me to produce a judgment, my lords. Unfortunately, the respondent bank is not present, my lords. Yesterday he was there.
Who is there? Who is the counsel?
My lords, one Mr. Ashok Nayak and Annapurna, his colleague.
A.N. Krishnaswamy for R2. Who is R2?
My lords, there is no R2, my lords. There is only 60, my lords. Serial number 60.
What is that you have given? I'm looking at the cause list, on the cause title. It's 9. What is your number?
My lords, 4262 of 2026. my lord.
There Annapurna is there. Indian Bank.
Srimati Annapurna, colleague of Mr. Ashok Nayak. Yesterday he was there, my lords, but unfortunately in the first round he was not present and also now he is
Just
not
file the
present.
wakalat. If she is not, we'll give some other counsel. And that apart, you have to convince the court.
Yes,
What was
my
the
lord.
writ petition for?
My lords, the writ petition is only about consideration of my representation for requesting total of 6 months extension, my lords.
You said yesterday, Lok Adalat
Yes,
award, I
yes.
have to extend it. So please
My lords,
show.
not Lok Adalat, my lords, but similar writ petition was filed before the coordinate bench. My lords, I have given the
I've
judgment.
already told you, coordinate bench entertaining the writ petition cannot be a ground to entertain.
Yes, my lords.
I want you to tell me in a Lok Adalat award, seeking extension of time, a writ petition is maintained.
My lords,
It is
seeking
not
for
maintained.
extension, there is no such writ petition, my lords.
Please understand.
Yes.
We shouldn't be doing something contrary to law under the guise of, helping. It's not, it doesn't amount to helping.
Yes,
It
my
is
lords,
more
but-
or less doing some illegality.
My lords, can I make one submission, my lords? My lords, before the filing of writ petition, the petitioner has deposited 1 crore 76 lakhs.
Might be,
My
please
lords,
understand.
my lords, two more submissions. 1 crore 76 lakhs he has submitted, I mean, he has deposited.
Just
my lords.
accept that he has
My lords,
deposited.
after
entire
the writ
amount.
petition, my lords,
He has-
my
he
lords,
has
after
deposited-
the writ petition
He has
also.
deposited entire amount, only 1,000 is left. Even for 1,000 rupees also, we will not entertain
My
the
lords,
writ
even
petition.
today, yesterday the outstanding was 39 lakhs. Even today he has deposited 14 lakhs And that outstanding has come up to 25 lakhs, my lords. My lords, my only,
You're all got used to saying something on facts. Please say something on law also.
my lords, on law, my lords, my lords, there is,
Not an
my lords, in
award
this
that has
judgment, my
attained,
lords.
and any award that is passed with the Lok Adalat, you can't, you can question it only on the ground of fraud.
Fraud, yes.
You are not pleading
No, my
fraud.
lords, I am not.
If you are
I'm-
not pleading fraud, it is not open to revisit an award. That is a settled proposition of law.
Yes,
If
my
you
lords.
say, you show me any law that says that it is permissible, I will entertain. But not on the fact that the coordinate bench has entertained, because coordinate bench has gone into law.
Yes. My lords,
That's why I
can
was
I,
making it very clear
my
yesterday.
lords,
to
can
you.
I make one submission, my lords?
Yes.
My lords, a date may be fixed in this writ petition, my lords. That 25 lakhs, my lords, I am ready to deposit with the DD. My lords, in 2 installments or the duration fixed by this court, my lords.
You've been appearing regularly and you know that it doesn't
Yes,
make
my
any
lords.
difference.
My lords,
And
I
will not-
understand, my lords.
I will not pass any order contrary to law for any purpose.
Yes, my lords, I understand, my lords. But the only issue here is,
However,
my lords,
you know,
it is
if-
a residential
If
property.
our
my lords.
only problem has a remedy before this court would definitely entertain.
Yes,
We cannot do it. And let us not make a bad precedent of this nature.
yes,
If
ma'am.
just imagine, if every Lok Adalat has to be questioned before this court for any other order,
My lords, I'm not,
there is no sanctity.
my lords, I'm not questioning the Lok Adalat order
You will
itself, my
not,
lords.
you will not.
My
Now,
lords,
this
I'm
becomes
not questioning. I'm only requesting the time of this.
What be done? Please come, the writ petition is filed, seeking the following prayer. Land council appearing for the petitioner submits.
My lords, in this case, the bank themselves have extended the time till 17/3.
Then
Today is the last date.
that is between you people, you can do anything.
My lords,
But
can
court
it be
has to write
posted?
a-
My lords, can it be posted next week, my lords?
Yes.
If the client is ready to deposit that 25 lakhs,
And
this
that
writ
I will
petition will be
not
disposed.
say, I will,
Yes,
next
yes.
week also I'm going to discuss it. Does this matter on 26th of March?
Yes.
And this made clear that a writ petition of this nature is not maintainable. Land council for the petitioner seeks time to get instructions. Yes.
Grateful.
List number 2, serial number 4. Crossover, list number 2, serial number 4.
For the petitioner, my lords, listen, endorsement has been issued by the police authorities, my lords, wherein a complaint was made for taking action against the erring authorities. Now, my lords, the state says that there's an alternative remedy under the Police Act, but the officials against whom I want an inquiry to be conducted, these are the forest officials.
Is it?
Forest officials.
Mhm.
My lords, the genesis of the case is this, my lords. The forest officials, by their own register a case on two,
No, forest official is also an officer
my lords,
of the department.
under department, my
Any
lords.
criminal action against him is permissible.
My lords, that is true, my lords, but when it comes to preferring an appeal under Police Act, that is not maintainable because he's not a police officer under Police Act.
Then I go before the, go and file a complaint against them, private complaint.
No, my lords, what has happened, my lords, the case is this, my lords.
That's
Well,
what
that's
you-
on
No, I'll tell you. The difficulty is, there are so many disputes, you say something
Please,
that he has done. He'll come up with saying that something he has not done it. These are all the disputed questions of fact, which will be adjudicated by a competent court, which has a mechanism of, looking at the evidence, examining the parties and all. So that's why we don't entertain a petition of this nature.
No, my
By
lords.
this time, if you have filed a private complaint against him, who should have
No, my
considered
lords,
it?
what has happened, my lords, I have made a complaint before the jurisdictional police to the SP. They did not do anything. They
That's a
approached this
private
honorable
complaint.
court, my lords.
That's
This,
a private complaint.
my lords, what has happened, my lords, even at the behest of this honorable court, my lords, the superintendent gives a report stating that no coercive action has been taken place. But what has happened, my lords, when there was a bail granted to in my favor.
Go before the, please avail that.
Paragraph 5 of my statement of objections. Paragraph 5
Let's-
of my
if-
statement of objections. Since there was a case registered against the petitioner, my lord, by the forest officials, my lord, he made an allegation. When he produced it before the magistrate, my lord, there is no allegation against the forest officials. No, my lord, in the present writ petition, he making allegations.
He has appeared before the magistrate before the filing the writ petition or after filing the writ petition?
Before filing
Before
writ
filing
petition.
writ petition.
Where are your objections?
Paragraph
My lords,
5, my lord.
as bail was granted in my favor, my lords.
No, the magistrate will not ask you if they have been arrested by the police.
Is there any
The
harassment?
court will ask or not, any treatment by the
Ill
police.
treatment.
They have
Nothing
asked-
When you
has
have
been-
stated so, that police have not ill-treated you, is it open to you to come before the court saying that there is ill-treatment from the police?
My lords, my complaint is this, my lords, when bail has been granted in my favor, thereafter the police come and arrest me. They make me go through the medical examination process. They make me loiter between.
After the bail.
After the bail. That is my case, my lords. 4, I secure a bail. 5, they arrest me.
Please go before the court and file a private complaint against the concern.
My lords, if I may request them, let my senior, my lords, tomorrow, my lords.
Not tomorrow. Tomorrow not possible. Tomorrow I have a full bench. This is matter on 23rd. Yes.
Number 6. Srinivas HK.
My lord. Lord, I filed an IA for vacating of the stay.
Morning, they were not there.
Yes, my lord.
For dismissal tomorrow. No representation. Yes, sir.
8.
In this matter, my lord, they filed a complaint before the jurisdiction police, my lord. Thereafter, my lord, they filed a suit and they obtained the interim order, my lord. Now they are not representing, my lord.
7.
Yes, 8, my lord, serial number 8.
For dismissal, no representation. Yes, 9.
9 is disposed.
10 is done.
Also urgent.
Yes. Now that matter which I said I'll take it up at 4:15. List that matter tomorrow at 1:15. Under the caption 1:15. I'll take up at 10.
Serial number 39. In
30?
list 39 in list 1, it was passed over, my lords.
We are not there.
No, I'm sorry, my lords. I was on my legs. I'm extremely sorry for
Yes.
I'm appearing for the respondent number 1.
that. I appeal for R3.
Respondent.
Yes, what is the writ petition?
My lords, the writ petition, my lords, is challenging the powers of the respondent number 1, that's ICICI Bank, my lords, to initiate DRT proceedings, my lords, under section 19 of the RDBF Act, my lords. On the ground that, my lords, it's without jurisdiction.
1 minute.
That's if it's not inconvenient, my lords, may I request my lords to have it either tomorrow, my lords, or on Monday. I have no difficulty in arguing. The only thing is that, my lords, other courts are also reaching. The other matters are also reaching. I'm only requesting for that purpose. Only because I don't.
Not take tomorrow. Let this matter on 2nd of April.
Grateful, lords. But there's an interim order.
Stay is granted.
When is it granted?
Lords, it was granted in 2022. They objected for it.
I'll have it tomorrow.
Please, my lords.
Tomorrow.
Yes, please. It's my request on the top, my lords, if that's.
No top. You can't have so many privileges, Mr. Counsel. Tell the court that I have worked in the other court and
No,
you want
that's
adjournment.
the chief.
And you now tell that let it be taken up on the top of the list. I'll list this matter on the last, as the last case. And this matter, 1:15, that 4:15 matter I said, tomorrow it should come at 1:15, not before that.
There's one more. 4:15.
Yes, all those matters are coming up on Friday.
ಅದನ್ನ ಬರ್ದ್ಬಿಡಿ ಬರ್ದ್ಬಿಟ್ಟು ಟೈಪ್ ಮಾಡಿ ತೆಗಿಸಿ ಹಾ ಈಗ 39 ಫೈಲ್ ಇದೆ ಅದು ಯಾರು?
ಇವ್ರು ಕೇಳ್ಬೇಕು ಅನ್ನೋ ತುಂಬಾ ಟೈಮ್.
Hello, sir. Hello. Sir, Matthew J. Nidupara, sir.
Yes,
Sir, your
yes,
matter
madam.
is, yes, sir, your matter is urgent to tomorrow 1:15 PM, sir. The matter will be called out in the open court on 1:15 PM tomorrow.
Thank you so much, madam. Yes. 1:15.
Yes,
Okay, ma'am.
because
Okay, ma'am.
the list is completed early, that advocates have taken adjournments in the previous matters. So that's
Okay,
why that
okay.
the court is,
So
okay, okay,
so kind of you, madam. So kind of you. Huh?
okay,
Right.
okay.
Thank you. Thanks a
Tomorrow
lot.
1:15, tomorrow
1:15.
1:15 PM, 1:15
Oh,
PM.
yeah. Okay, ma'am. Make it 1 o'clock, madam. It will require at least half an hour.
Okay, sir.
Make it 1 o'clock. Huh?
Okay, 1:15
Okay.
PM tomorrow.
Okay, bye.